Okay, hello again. This is March 21, 2016. This is the second of a series of lectures on the Commerce Clause from the New Deal through the Affordable Care Act case. We left off with the election of 1936 and the court packing plan. I'm on slide number 8 on your PowerPoint. And just to go back a little and reiterate, I mean, FDR's position is the New Deal position on the situation, which justifies the court packing plan. His view is, and it's a common view of what the court was doing during the New Deal, is that the justices are legislating their preferences. They're sitting as a super legislature. They're unelected. They're unaccountable. They're repeatedly using the vague generalities of the Constitution to strike down the laws that the people want, the democratic will of the people. Constitution is fine. The problem is the justices. So an amendment process would be inadvisable, unwarranted, and probably couldn't succeed. So the court packing plan is the answer to the illegitimacy of what the court's been doing, striking down all these New Deal measures. There's an alternative view of that, which I'll get to in a minute. But that's his position. One could oppose, as many of you did, the court packing plan on separation of powers grounds that there are fundamental structural features of the Constitution that we can't dispense with, and the court packing plan threatens to do very severe damage over the longer term. It would destroy the delicate balance of the Constitution. Well, we don't know, how this would play out in full. The bill is proposed. It's never enacted largely because the court pretty quickly shifts its understanding of what the Constitution allows governments to do. So on slide number 8, it's not a case we've read yet. We'll read it later in the semester, but within a month or so of the proposed bill, the court decides a case called West Coast Hotel v. Parrish. It's about a state minimum wage law. The court had been striking down a lot of state-level interventions in the economy as well. Just as recently as 1936, it struck down a minimum wage law in New York State. In West Coast Hotel, the two middle justices, Roberts and Hughes, vote with the three liberals to uphold a state minimum wage law in Washington State, and that signals a shift. Roberts' move in particular becomes known as the switch in time that saved 9. Historians have figured out that he decided his vote in this case before the court packing plan was announced. I don't think it matters. I mean, I think what matters is the overall overarching change in the court's direction, which is clearly influenced by the court packing plan. Whatever Roberts thought about the particular nuances of this case doesn't matter so much. But that signals the change. And then moving over to slide 9, this is a case that we are reading. It's the NLRB v. Jones and Laughlin Steel, and this is the issue about whether Congress has the power under the Commerce Clause to enact the National Labor Relations Act. The steel company is charged with violations of the act, unfair labor practices. It fired employees who were involved in union organizing, and its defense is that Congress doesn't have the power to regulate us like this. It doesn't have the power under the Commerce Clause to do this, and that sets up the issue. The argument for the power is that industrial peace is vital to the national economy and the health of the national economy, and even if it happens locally, if it has this impact on interstate commerce, Congress can reach it. It can reach whatever it has to reach to preserve interstate commerce if there's a substantial relation or a substantial effect on interstate commerce. So we see the shift in the court's approach. You want to sort of pay attention to the rhetoric and the nuances of Chief Justice Hughes' opinion for the court. It's 5-4. So again, Hughes and Roberts go with the three liberals. They uphold the act. The reasoning is all of a sudden more empirical and practical. The logical categories, the fundamental difference between manufacturing and commerce doesn't matter so much. That's not controlling, Hughes writes. What matters now, he says, are the facts of an integrated national economy. And he says, and I quote, the effect on commerce, not the source of the injury to it, is the criterion. So it's the impact on commerce, not what you call the harm or the targeted activity. There is, he says, still some line. There must be some line between what's national and what's local. We're not saying that Congress's power is unlimited. We're not saying what those limits are, but we know that in this law, Congress has not overstepped its bounds. This is a constitutional measure. The question is, he says, necessarily one of degree. Now, on slide 10, I've given you what I think is a key quote from Hughes's opinion about the national economy and what Congress can do. And you just see the tone there. Congress may enter when it's necessary to protect interstate commerce from the paralyzing consequences of industrial war, right? Interstate commerce is a practical conception, right? Judgments have to be based on our actual experience. So it's a different kind of mindset. The 4 dissenters stick with the old view, but they're now outvoted 5-4. I'm going to skip a couple slides. I have these slides a little bit out of order. So if you slide down to slide 13, we finish the story of how the threat of the court packing plan, which is never adopted, it dies in Congress, but the court shifts its view under the threat of it. In May, the court decides 2 cases upholding provisions of the Social Security Act of 1935. Again, that law would be suspect under the old view. How could Congress do these things? And their commerce clause is involved, the spending power is involved. Later that year, one of the conservatives retires, and he's replaced by Hugo Black of Alabama. FDR will make a total of 8 appointments, 7 after Black, between 1937 and 1944. So the court is remade in the image of the New Deal. And I just want to, it's like we could stop right here just to ask some larger questions, and then we'll go back to complete the account of the cases that we're reading, the Commerce Clause, the post-New Deal Commerce Clause cases. But back to slide 11. We do have to confront 2 basic views of judicial decision-making, and you could say the truth might be somewhere in between, but it's good to sort of have them out there. The New Deal understanding of what the court is doing from the late 1890s to the New Deal in striking down social and economic regulation. We could call it the political jurisprudence perspective. Judges are making political decisions, they're political actors, they have ideological preferences, they have biases, and they have to kind of dress up their decision making in the form of legal doctrine. Now, in terms of the New Deal, this is an understanding of the justices has kind of gotten out of control, that they're not elected, they're legislating their preferences, they're using the vague generalities in the Constitution, everything we said about the court packing plan's justification, and they're political actors making political decisions, which makes their interventions during the New Deal, more suspect and gives you a lesson of judicial restraint. If justices inevitably make policy decisions and they're not elected, they should try to defer to the democratic process. Another view of what the court was doing, right? So on that first view, that first New Deal view, the old court was threatening the democratic will of the people. The Constitution's adequate. It's flexible. It's fine. It's that the justices are drunk with their own power and their own, conservative ideology, and that's why they had to be knocked out of the way. The alternative view is that legal decision-making and legal doctrine have, more integrity than that. There is a set of constitutional values, and there are traditions. The justices before the New Deal are not just making it up. They're interpreting that tradition, that the market is freedom-enhancing, liberty-loving, that government really does need to be limited, that freedom of contract and property rights really need to be protected by an independent judiciary. And these are our constitutional traditions. These go back to the founding. Government shouldn't play favorites. Government should be neutral. We see this rhetoric in Federalist number 10. And that so what the alternative sort of formulation of the New Deal on this view would be that the New Deal did threaten the old Constitution. There was an old Constitution, but it made good on that threat. So the justices are speaking for the old Constitution. They're interpreting those values. And what the New Deal really is a constitutional amendment, functionally, structurally, changes the Constitution. And the justices were doing pretty much what we want them to do, which is looking backward and interpreting norms and values that are outside of themselves. And that matters, you know, it matters for your view of activism or restraint. It matters in terms of what you think the Constitution is and what it means after the New Deal and why. There's no way to resolve that question. You could view the New Deal as an amendment and still have a kind of a more skeptical or political view of judicial decision making. And then on slide 12, there are connected ideas about understanding the New Deal. The New Dealers tell a story, which is the first one, the court sort of against the people and against the Constitution. They write the history of it, and they don't write a history of we needed to change the Constitution and we did. They write a history of, you know, the bad old court, the anti-democratic court, and the need for judicial restraint. But the other view is that the court is enforcing old values, and then it shifts to a new setting, a new regime, a new set of values. And then how do we know what those values are, and what interpretive tools do we have to understand them? All right, so moving back to slide 13, this is not a case that we actually read, but it marks the change in the biggest way possible. This is clearly the most famous footnote in the court's entire history. It's known as the Caroline Products footnote. It's footnote number 4 in the case. The case itself is a case about a law passed by Congress that regulates the milk industry. And prior to 1935, if this law were challenged, it would be sort of up for grabs about whether the court might strike it down. It's a statute that has some problems with it. The Congress seems to be playing favorites in it. You know, it's not clear that it's within Congress's commerce power. It might be up in the air. But in the body of the case, in 1938, the court is basically saying, and this is what becomes known as the rational basis test, the court is basically saying, you know, we're not doing that anymore. We're not sitting in judgment of the judgments of Congress and second-guessing Congress about what is or isn't related to or necessary to protecting interstate commerce. We're going to bend over backwards to defer to their judgments. If a sane person could think that there was a connection or a basis for this law, then it's okay. It's not whether we think it's right or good or wise. It's whether a person who isn't crazy might think that. So it's extreme deference to Congress, known as the minimal rationality test, right? They're democratic, and the people can control them. You know, if a part of the milk industry doesn't like the Filled Milk Act, they can go to democratic politics and get it changed, right? So we're out of that business. We're not going to sit in judgment of social or economic regulation anymore. But at that precise point where it articulates that very deferential standard to Congress, it drops this footnote. And the footnote says there are 3 areas or kinds of cases where we might consider being more activist and we might strike down laws. And this actually sets out the agenda for the court for the next couple of generations. And I put the 3 paragraphs of the footnote. It's on page 178 of your text, is one of the places it appears. But there are 3 paragraphs, 3 ideas. It's hard to understand what Justice Stone is saying in this footnote, but I can kind of paraphrase. We might be more likely to strike down laws when they appear to violate what he calls the specific provisions of the Bill of Rights. Now, he doesn't say just the Bill of Rights. He says whenever I see something in the Constitution that looks like a rule, I'm not legislating my preferences. I'm not using liberty or interstate commerce. I'm using something specific in the Constitution I can regard as law. It's the law, it's not me. And if the law violates that rule in the Constitution, I can strike it down. But he does go out of his way to say, like the Bill of Rights. How specific are the provisions of the Bill of Rights, and is that a difference compared to interstate commerce or the word liberty in the 14th Amendment? A lot of those provisions are not terribly specific. You might have more of a narrow compass about what you're talking about. We know we're talking about free speech or unreasonable searches and seizures. Well, we're going to debate what's a search, what's a seizure. You have to decide, but the claim is that I'm on firmer ground legally if I can point to a constitutional text. The subtext is, maybe human rights will be our agenda, and maybe in a newly expanded administrative state, that should be our agenda, right? The relationship between the individual and the government, now that there really is a government, that might be important for the court that might be an area of concern the court would carve out for itself. Second paragraph, it's unnecessary to consider now, that is, think about it, legislation which restricts political processes which can ordinarily be expected to bring about a change in bad law. What he has in mind here are look, so okay, the New Deal happened, we're Democrats now. The people decide through the democratic process. But if the democratic process is rigged, if people can't vote, or people don't have the right to free speech, we may be on firm ground making sure that process is fair so that the outcomes are fair. So if there are rules and laws that restrict the process, we might be more active in striking those kinds of laws down. Third paragraph on the next slide. Nor need we inquire. Again, we don't need to think about it, but let's think about it. There might be similar defects with the democratic process if certain minorities, not all minorities, but certain minorities are identifiable, discrete, insular, and they're hated. They're subject to prejudice and stigma. If you're an African American in Topeka, Kansas in 1952, doesn't help you, for me, to tell you to go to the democratic process to participate and get the results you want because you're locked out of it. So there might be a special role for the court in protecting minorities like blacks or Jehovah's Witnesses who are subject to irrational hatred and vilification and won't ever get a fair shake in the democratic process. It's a rationality defect in the democratic process, and the court will be doing that after 1938. It'll be doing all of these things. It'll incorporate the Bill of Rights and protect the Bill of Rights nationally. It will police the political process, one person, one vote, freedom of speech, and it will protect minority groups. So it's kind of a symbolic and clear statement of the court's new agenda in the third era. Now, slide 16, moving on to the Commerce Clause cases. Darby is a case, let me just find my notes, sorry. It's very not rehearsed at all. You know what, let me do my Rubio imitation, see? And it's 4:46 right now. I have a 5 o'clock rule, so in the next video that'll be a nice cold bottle of beer. Darby, right? So Darby involves a law called the Fair Labor Standards Act of 1938. And it involves a maximum, maximum hours, minimum wages, time and a half for overtime, working conditions. And what it does is it fixes hours and wages for producers who ship goods in interstate commerce. So if you ship goods in interstate commerce, you're subject to these rules. And it also bans the interstate shipment of goods produced in violation of the standards. And Darby's a Georgia lumber company, and it's charged with a violation of the act, and its defense is, again, Congress doesn't have the power to do this. And everything the court has said up until 1937 would lead you to conclude, like Hammer v. Dagenhart and Schechter and Carter Cole, that Congress doesn't have the power to do this under the Commerce Clause. But we're post-New Deal, and it's 9-0. The court unanimously upholds the law. And the argument is that these practices are injurious to economic development and fair competition, right? And we always in these cases, there's a concern about the race to the bottom, that if one state has robust standards, labor standards, and another state doesn't, the state without the labor standards has a competitive advantage in drawing businesses and getting business investments. So it's the race to the bottom issue. Um, and the court is very clear about the fact that it's just a question of power, and we bend over backwards to defer to Congress. It's not a question of their motive. Their motive could be humanitarian, welfare of the worker, but what it's actually doing is within its power. I'm going to ignore that call, so you should too. Call from Person Lakes A. Solicitation. I can't manage to get on those lists. I try to get on those lists. They get me off of these solicitations, but I haven't figured it out yet. So if any of you have any advice on that score, let me know, okay? Hammer v. Dagenhart is explicitly overruled. We don't care about the motive of Congress, right? And the judgment is for Congress. If people don't like this judgment that Congress has made about how connected fair labor standards are to interstate commerce, it can unelect the representatives and repeal the law. The answer is the democratic process, right? And one final point that leads into Wickard and Filburn is, well, this guy Darby in Georgia, it's a very small business, how could this little business in Georgia have such an effect on interstate commerce? And the court's answer is the aggregation answer. It's that, well, you multiply those little effects, many, many times, and you could have a big effect, right? This aggregation idea is taken to an extreme in the next case, Wickard v. Filburn, and that becomes an important case for us. In the marijuana case and the Affordable Care Act case, Wickard is a significant kind of precedent that people regard as precedent and have to kind of engage with, right? One final point about Darby is Stone writes that the 10th Amendment, which says, the power is not delegated to the United States by the Constitution nor prohibited by it to the states, are reserved to the states respectively or to the people. This was a key provision for federalism and state autonomy. The 10th Amendment is an expression of a sense of a limit. It doesn't have any content, right? It's kind of a rule of construction, like the 9th Amendment. It doesn't have much content. It doesn't have any content. Stone's point is that he says it states a truism. Yeah, okay. Whatever isn't granted is reserved, but we're still left with the same question: what's been granted, and how far do these powers extend, and why? This brings us to slide number 18 and Wickard and Filburn, 1942 case. It's on page 330 of your Brettschneider text. Filburn is a small dairy farmer in Ohio, and he's challenging the marketing provision of the Agricultural Adjustment Act of 1938. Again, these are price supports, subsidies to farmers not to grow in order to limit supply, raise price, and stabilize agricultural markets. The particular market at issue here is the wheat market, which we will be concerned to talk about in relation to the pot market in the 2006 case. Under the law, he's allowed to grow 223 bushels of wheat. And he grows 16 extra bushels. He doesn't intend to sell it. He intends to use it for himself as feed. He's going to consume it. And he's fined $117 for going over the quota. And he challenges this interpretation and application of the law because it's for his own use, his own consumption. I mean, you could say, look, it's not a commodity, it's not commerce. How is it commerce? He's not bringing it to market. It starts to look like excessive government reaching into his pocket, into his personal life. So he challenges it on that basis. Justice Jackson's opinion, again, for a unanimous court, right, kind of goes back to Chief Justice Marshall. The commerce power is broad. Once we say it's within the power of Congress, they're going to judge the extent of their intervention and what makes sense and what doesn't, right? And again, the idea that the restraints on Congress's power in this area have to come from the people, not from the courts, right? And Jackson's argument is that even if you say this isn't commerce, even if you say it's not commercial, it's not a commodity, that doesn't mean Congress can't reach it, right? Now, I don't know how important it is that it's a potential commodity. I think it's important that it is potentially a commodity, right? That's the logic of the aggregation theory. And there are two aspects to this in the court's reasoning. One is what he consumes for home consumption, he doesn't buy in the marketplace. And again, if you multiply that by thousands and thousands of people, there could be an effect on the market that Congress has the power to and is trying to regulate. And also, it sits there, it overhangs the market. It's not a commodity now, but if a lot of people are doing this and the price rises, then it could come into the market and destabilize this very carefully constructed effort to regulate the market and stabilize prices. So those two aspects add up to Congress can reach it. It's trivial in itself, but aggregated it could be significant. Do we have to show? Do we need an empirical showing that this is real? No. We defer to Congress, and we don't even look into it, right? It's like if Congress made that judgment, supposition, fine. It's not for the court to judge. So taking NLRB and Jones and Laughlin Steel, Darby, Wickard together, you have a vastly expanded power of Congress to regulate interstate commerce, right? And an extreme deference to congressional judgments, right? It's for Congress to say that something does or doesn't substantially affect commerce, and the court really should bend over backwards to defer to that judgment. And the people are the control, not the courts. Is this total abdication wise? Is it good? Is it right? Should there be judicially imposed standards and limits on Congress's power? The extent of Congress's power is taken even further. We got 3 slides to go for this segment. Slide 21, and this is a little weird, so I'm going to have to take a minute or two to kind of explain this. Provisions of the Civil Rights Act of 1964 reach what we used to regard as kind of the private sector, right? Employers can no longer deny people jobs on the basis of race under Title VII. Public accommodations, hotels, restaurants, theaters, lunch counters, they can't refuse to serve people on the basis of race. And one would think that kind of a human rights law would come from Congress's power to legislate under the 14th Amendment. And that's part of the conversation, but mainly Congress rests its power to ban discrimination in public accommodations on the Commerce Clause, on the idea that discrimination in a hotel or a restaurant has a negative impact on interstate commerce, and therefore Congress can ban it. Now, why not rely on the 14th Amendment? Well, on slide 21, I've given you the relevant provisions of the 14th Amendment. I'm going to be very brief about this. We'll get back to it. But in an 1883 case, a case called the Civil Rights Cases, that involved a law very much like the 1964 law. That law was passed by Congress in 1875, and it did the same thing. The Supreme Court held that Congress does have power to legislate under the 14th Amendment, but when it legislates, it must target state action. We're going to see this argument come up again in the Morrison case, the Violence Against Women Act case, and the civil remedy provision of that law. And if it's not targeting the state, or not doing something that responds to some defect of what the state is doing, it's outside its power under the 14th Amendment. Section 1 says no state shall. Congress can legislate to pursue or further or implement those rights, but the target of its legislation has to be the government. So we can get into conversations about what is or isn't state action, but the Heart of Atlanta Motel is not the government of Georgia, right? So instead of trying to, and this would be a vast expansion of the reach of government if we dispensed with the state action requirement for the 14th Amendment. But rather than do that, Congress is looking at the history of the Commerce Clause and saying, haha, this is economic activity, right? Ollie's Barbecue, Heart of Atlanta Motel, they're businesses. We can reach them with anti-discrimination law under the Commerce Clause, and it does. And then the court really just signs off on this without a hitch, without a problem. Congress doesn't make an empirical record or findings to show the connection between not serving a black person in a restaurant or not renting to a black person in a hotel and harm to the national economy. It's kind of intuited. People are more likely not to travel. Business activities likely to be impeded. Okay. It's upheld on the loosest possible standard. The court says that the test is, and this is on Brettschneider, page 334, the test is whether the activity regulated, quote, is commerce that concerns more states than one and has a real and substantial relation not to commerce but to the national interests, right? And so this is the logic of Heart of Atlanta and the Katzenbach v. McClung case, which involves Ollie's Barbecue in Birmingham. Ollie's Barbecue is a very local place. It's a restaurant in Birmingham, seats about 200 people. Most of what it buys locally. Now, some of the food product it buys from people who themselves got it from out of state. It's somewhere near an interstate highway, but what's the connection to interstate commerce? Doesn't matter. Congress can reach this under its commerce power. Because of supposed links to interstate commerce. So the court is saying, you don't need what's known as a jurisdictional element. We don't have to show some tight connection between something you have there and interstate commerce. We don't need to make findings of facts about the nexus. We bend over backwards to defer to Congress. Just to complete the story up through the 90s, Congress enacts a lot of laws under its commerce power. One of the most sort of common kind is a federal crime policy, right? Federalizing crimes. And in one significant case, Congress passed a law making loan sharking a federal crime. Is that connected to interstate commerce, right? The loan shark at issue in this case was doing his loan sharking locally. Right? What's the basis? Right? It occurs within one state. And Congress concluded that this criminal activity may have a substantial negative effect on the markets it wants to regulate. So the court signs off on that. It doesn't strike down laws that Congress passes if Congress invokes its commerce power and it's imaginable that there's some connection. But Lopez changes that. Lopez in 1994 is the first case in which Congress strikes down a law passed by Congress under its commerce power since 1937. So I'm at 34 minutes, and the third installment, I think we'll go from Lopez right through the Affordable Care Act case in the next video, just to limit the number of videos you have to deal with. So I'll see you in a little bit.